engage yourself into the discussion that we'll be just venturing into. Just a small correction as we go forward with. I would have loved to intern under the chambers of late Ram Jethmalani sir, but unfortunately I did not intern under him, but definitely did receive a small award under his name. Nonetheless, I would like to thank Mr. Nitesh for giving me this opportunity and coming on this platform to speak on a topic which is a very interesting area, which explores the impacts of pandemics like COVID-19 on life-saving drugs. Having said this, I would like to begin by saying that in the absence of any public interventions, we will remain reliant for life-saving drugs and vaccines on a monopoly-driven system that favors profits over people. As India has witnessed slogans like patent skill patients, I am here today to have a discussion on the similar lines and over the topic patent laws, impact of COVID-19 on drugs, especially life-saving drugs, and whether in times of pandemic, patenting these life-saving drugs is a viable solution, and much more. My discussion today for better understanding of the present topic would start by talking about an introduction to the patent laws. I'll talk about a little about what is the history of patent in India, what are the patents, how to obtain a patent, advantages one gets in patenting an invention, rights and obligations of a patentee, transfer of patent rights, compulsory licensing, and thereafter talking about revocation of patents. This will give us a brief understanding and introduction into patent laws. Thereby, after establishing the said introductions into patent laws, I would like to further dwell upon the main topic of today, which is the impact of COVID-19 on life-saving drugs. On the impact of COVID-19 on life-saving drugs, I'll touch upon the available experimental drug which we have today, which is the Remdesivir. Talking about thereafter US Gilead approach in patenting the said drug. US Gilead is a biopharmaceutical company which apparently claims to develop this experimental drug. Thereafter, I'll establish upon approaches and strategies which are available to combat monopolization of life-saving drugs in times of such crisis. And lastly, I'll be touching upon the topic that is patenting the only viable solution present with us, and how far do we go with the same. Giving this brief introduction, commercial pharmaceutical companies have for decades been privatizing and locking up the knowledge commons by extending control over life-saving drugs through unwarranted, frivolous, and secondary patents being filing and lobbying against such arenas. With the arrival of any pandemic, it is painfully obvious that such monopolization of drugs would be at the cost of human lives. COVID-19 has without doubt invented and initiated a new IP saga. What is the impact of IP on the COVID-19 crisis, and how well do relevant exceptions into the patent law, which we will see in my discussion, such as compulsory licensing, really work in such extraordinary circumstances? A few arenas that we'll be deliberating upon today. Indian patent law has several mechanisms to deal with potential abuse of patent systems, as well as to ensure affordable access to medicines and public facilities. So among these provisions against combating such abuse to life-saving drugs or patent system, we have options like evergreening as a defense mechanism to combat such abuse. Evergreening meaning hereby the practice whereby pharmaceutical companies extend the patent life of a drug to further an additional 20 years of the said process, thereby making some minor reformulations or other interrelations of the drug without necessarily increasing the efficacy or the efficiency of the drug at hand. Other means to combat such abuses in patent system are second indications under patent law. What is second indication primarily? Second indication meaning thereby that when a brand name drug's patent is about to expire, allowing this not to be undermined by cheaper generic drugs available into the market, the companies thereafter, by doing certain innovations and by going forward with certain other inventions into the said drug, they come up with a second indication and a second patent, which thereby gets registration into the patent system. And furthermore, there are other arenas under the patent law, under the compulsory licensing scheme, and also revocations which are available, which are formulations which help in combating possible patent abuse. So in today's topic, these are two unexplored provisions of the Indian patents that have potential aspects to gain, particularly, and are very relevant in the present pandemic times, which are about compulsory licensing and revocation of patents. Compulsory licensing finds its place into patents law under section 84, and revocation finds its place under section 64. We now see that there can be a significant for access to diagnostic kits and vaccines and drugs and undergoing trials like Remdesivir, which are covered by existing patents. These clauses will not only be relevant for any vaccine or drug that is still in the stage of development and for which patent applications are still pending. Having given a brief introduction as to what is the present situation that we are facing in terms to life-saving drugs, now I dwell into the patent regime, a little bit about the patent regime in India. The Patent Act 1970 is more than 100 years old and having its root from the 1949 Patents Act of UK. The first act relating to the patents was passed in 1956 under Act 6 of 1856, which granted exclusive privileges to inventors and new manufacturers for a period of 14 years. Thereafter, this act was found defective and therefore reenacted with modifications under Act 15 of 1859. Thereafter came the 1872 Act of Patents and Designs Protection Act, followed by a Protection of Inventions Act 1883. These acts were all consolidated into the Invention and Designs Act of 1911, which was thereafter, which replaced all the existing acts at that moment. So after the 1911 Act, there have been various amendments into the said patent law from 1911 to 1970. In 1957, the Government of India requested Justice N. Rajagopala Iyengar, along with Dr. S. Venkateshwaran, to advise the government on the question of revision of patent law. Sri Iyengar submitted his report in 1959, which lapsed, but thereafter an amended bill came up into picture, and that culminated into 1970, the present act which you have today, which is the patent law. So the basic principles of patent laws are broadly the same overall in the entire world, but there are few major differences in relation to the systems of how one approaches patent law. And however, the genesis of patent law lies in development of technology and improvement in industrial techniques, the said aspect is generally the same in all countries. Now, what is a patent? A patent is an exclusive right which is granted to a person who is called a patentee, who has invented a new and useful article or an improvement of an existing article or a new process of making an article. As per Halsbury Laws of England, 4th edition, volume 35, para 303, the word patent denotes monopoly right of an invention. As per the Supreme Court case of Bishwanath Prasad Radhe versus Hindustan Metal Industries, 1979, 2 SCC 511, at page 517, Justice Sarkaria further dwelled into the definition of patent, and I quote, "The fundamental principle of a patent is that a patent is granted only for an invention which must be new and useful. That is to say, it must have novelty and utility. It is essential for the validity of a patent that it must be the inventor's own discovery as opposed to a mere verification of what was already present into the world or something which was already there back then. Thereafter, an application for a patent can only be made by a person who claims to be the true inventor of the patent or an assignee of the true and first inventor in respect of the right to make an application, or the legal representative of a deceased person who immediately before the death was entitled to apply for the said patent as per section 6(1) and 6(2) of the 1970 Patent Act. Further process of filing a patent can be found into the Patents Act, and we all can have a search into that, which ranges from Section 6 to 11 of the Act, Rule 10 to 16 of the Patent Rules 2003. Further, how to get a patent is another question that we need to see. So what happens is that the examiner conducts a search into the Indian patent database, starting from 1st January 1912, and all available database, including patent and non-patent literature, are analyzed. And the examiner in this scenario sees whether there is some sort of an invention or some sort of similar claims which exist into the market since 1/1/1912. Furthermore, the examiner also checks on few different aspects. First aspect to check, or first aspect that we need to see if we want a patent, is novelty. Novelty, or meaning thereby new, a new invention, which is defined under Section 21J of the Patents Act, also has references in Section 13, 29, and 34. An invention is considered as a new invention if it is not anticipated by prior publication in patent and non-patent literature, prior use, or prior public knowledge. So something which is not there in public domain before the filing of an application by a patentee is considered to be a novel approach or a novel invention. Furthermore, aspects to consider to get a patent are inventive step. So there's something called an inventive step in patents law, which is defined under Section 21J of the Patents Act, also 21JA. What is an inventive step? An inventive step is a feature of an invention that involves technical advance compared to the existing knowledge, or have economic significance, or both, that make an invention not obvious to a person skilled in the economic field or a person skilled in that art. While determining the patentability of the invention, an examiner first conducts investigation as to whether the novelty of the claimed invention is established, and thereafter proceeds whether or not the said invention has an inventive step or not. So furthermore, on what is an inventive step, we have references from the Supreme Court case of F. Hoffman Roche versus Siplan, one of 2008, wherein I correct myself, the F. Hoffman versus Cipla. We have references from Delhi High Court, wherein the Delhi High Court observed the test of what is obvious. So the Delhi High Court reiterated the said principles of how to get a patent is that something which is not prior published in the market, or somebody who is skilled in the said art who doesn't see the said invention and doesn't guess as to what the invention could be. So a person skilled in the art cannot technically come up with what exactly this patent is. So such are the various tests which define the obviousness of getting a patent. Furthermore, industrial applicability is very important to get a patent. So what is industrial applicability? Industrial applicability is defined under Section 21AC of the Patents Act, which says that the said invention should have some use in the industry or should have an industrial application. Then only you will be able to get a patent. So having said these, Section 3A to Section 3P deals with what cannot be patented. So Section 3 deals with an invention which is frivolous or which claims anything obvious contrary to what is well established in laws cannot be an invention and thus cannot be patented. So some examples of a frivolous nature or contrary to natures of laws which cannot be patented, or such inventions could be something like a machine which alleges that it can give 100% efficiency, or a machine which alleges that without an input it can give an output. So such things fall under the criteria under the patents law which cannot be granted a patent. Furthermore, anything which is contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life also cannot be patented. Furthermore, the mere discovery of a scientific principle or a formulation of an abstract theory or discovery of any living thing is also not patentable. Furthermore, a mere discovery of something, of a known substance or a known form that doesn't result in the enhancement of a known efficacy of a substance will also not be patentable. So now here it's very important to understand that this particular provision under section 3, which says that something which doesn't enhance the efficacy will not be patentable, is pertinent to mention here in context to our present discussion of the life-saving drug that we have at hand today, which is the experimental drug apparently claimed to treat COVID-19 patients, the Remdesivir. So for the purpose of this clause that I was mentioning in relation to certain substances which do not enhance efficacy of an invention, they can be salts, they can be esters, they can be polymorphs, they can be metabolites, they can be pure forms, and so on and so forth, as they can be seen in section 3D of the Patents Act. These substances do not are substances which do not increase the efficacy of anything. So the Remdesivir, which I will in my further course of discussion come on to that, is something which is being claimed by certain associations in India should be revoked, because this particular patent does not increase the efficacy of an existing drug which we had at hand, and I will be dwelling upon that in my later course of discussion. Furthermore, dwelling into the introduction of patent laws, I'll highlight few advantages that patentees have when they go forward to protect their patent, protect their invention by patenting the said invention. So the certain advantages that patentees find are in the incentive for technological innovation, which is the monetary reward which patentees get. Either they can license the said patents, or they can thereafter assign the said patents, which are monetary rewards given to patents. Furthermore, exclusive right to use the invention for a limited time is also an advantage which patentees get. Furthermore, in case of a patented product, a patentee will have an exclusive right to also prevent third parties from acts of making, using, offering for sale, selling, or importing those products. And similar for patent process, which may be a process of developing a software, a patentee shall have the exclusive right to prevent third parties from the act of using that particular process. Furthermore, having established the basics of patent laws that we've just discussed, we now dwell into how patent rights can be transferred. So the transfer of patent rights under patent law can be found under section 68, 69, rule 90, 91 till 92, and can be filed under form 16 of the patent rules. So the transfer of patent rights could be broadly done by assignment or by licensing. An assignment of a patent or a share in a patent, a mortgage, license, or the creation of any other interest in a patent shall be valid only if the same were in writing and there was an agreement between the parties concerned, and the same was reduced in the form of a document embodying all the terms and conditions that the parties had in mind. Thereafter, licensing can also be another aspect of transfer of patent rights. Licensing could also be done in terms to compulsory licensing, and can also be done in licensing in general. So compulsory licensing under patent law is found under section 84 and can be done as per form 17 under the Patents Act. So what is compulsory licensing? Any person interested may make an application to the controller to grant a compulsory license for a patent after the expiry of 3 years from the date on which the said patent application was filed, on the following grounds: that firstly, the reasonable requirements of public with respect to the patented invention have not been satisfied. Secondly, that the patented invention is not available to the public at reasonable, affordable prices. And thirdly, that the patented invention does not work in India. So based on these three criteria, after the expiration of 3 years, a third party can come up to claim a compulsory license in a patent, which is done by an entity, if these three criteria, any one of them are established. Furthermore, the transfer of patent rights can also be done by licensing in general, which finds its way in section 91 of the Patents Act. So at any time after the grant of a patent, any person who has the right to work any other patented invention, either as patentee or a licensee thereof, exclusive or otherwise, may apply to the controller for a grant of license of the first mentioned patent on the said ground. Thereafter, compulsory license can also, the transfer of patent rights can also be done by a compulsory license or notification by the central government, which finds its relevance under Section 92 of the Patents Act. So if the central government is satisfied in respect of any patent in force in circumstances of a national emergency, or in circumstances of extreme emergency, or in circumstances in which there is a case of public non-commercial use, in such cases, if it's necessary and it deems necessary by the central government, compulsory licenses can be granted. Furthermore, Section 92 deals with compulsory license for export of patented pharmaceutical products in exceptional circumstances, which is also a way in which there can be a transfer of patent rights. Furthermore, a little bit more into the introduction of patent laws, we deal with what are the revocations of patents under Patent Act. So revocations of patent is dealt under Section 64 to 66 and 85 of the Patents Act. Revocation of a patent can be done before a high court or an appellate court. Any person or the central government may make a petition on any of the grounds specified for revocation of patents under Section 64 of the Patents Act and claim that the said patent may be revoked. Furthermore, revocation can also be done by the controller on direction to the central government as per Section 66, as per Section 65 of the Patents Act. Furthermore, revocation can also be done by the central government primarily, where the central government is of the opinion that a patent or the mode in which it is exercised is either mischievous to the state or generally prejudicial to the public. It may, after giving the patentee an opportunity to be heard, finally revoke the said patent. So, having dwelled into the introduction of patent very quickly and having touching upon basic aspects or principles under patent law, this will give you an understanding as to what would be the terminologies being used when I now dwell into the topic, which is the applicability of COVID-19 on life-saving drugs. Having said this, we face various problems today by patenting these life-saving drugs or equipments. Especially in today's scenario, we can see that there is a trend of monopoly control over the market. So monopoly control over the technology using in the testing for the viruses has hampered the rollout of more testing kits, just as 3Ms, the masks, and N95 masks have been on a rampant scale by different entities coming up on patenting the said masks under the title of respirators. And it has been difficult for new manufacturers to come up and to scale up with the present market. Furthermore, practical problems that we can witness today in terms to monopolizing the life-saving drug market is that the cost control analysis that would be done thereafter if a particular patent is granted to a life-saving drug would be harsh on the economies. So these are few areas which today the world is facing challenges with respect to COVID-19 on life-saving drugs, on patenting such life-saving drugs. So as the novel coronavirus pandemic, or the COVID-19 as we call it today, accelerates and continues to claim lives all over the globe, governments are ramping up efforts to find a cure. We all know that. This includes developing a vaccine to prevent the illness from spreading further, testing kits, and most importantly, formulating the right kind of drug to treat those who are already victims of COVID-19. Amidst this, the questions revolving around the outbreak of this pandemic remains how to deal with patent barriers to the production and provision of low-cost treatments, which I've just highlighted before right now in my said discussion. Under normal circumstances, most pharmaceutical companies would seek to enforce their patents and restrain any authorized use. However, in a global crisis like this, there is a pressure on these companies to waive off any proprietary rights they may have ordinarily claimed to facilitate universal distribution of drugs that may aid the fight against the widespread disease. Having said this, I would like to now touch upon the only life-saving experimental drug that we know about, is the Remdesivir, which apparently has been developed by Gilead, a US pharmaceutical company, as touched upon in my discussion earlier. So Remdesivir is presently considered the most promising candidate for the treatment of COVID-19 and is the subject of 3 patents granted, as I may tell you. This particular drug has already patent in India in 2016, in 2018, and has just received another patent in February 2020. Through the licenses, the licensee companies will be provided transfer of technology and would be able to set their own prices for the drug, which is the main criteria which Gilead is harping upon in the present circumstance, and I would be coming upon the same in my later course of discussion. So what exactly is Gilead doing with this experimental drug, and what is its approach towards patenting the said drug? In an official statement released on or around 12th May 2020, Gilead Sciences has announced signing voluntary patent license agreements with 4 Indian pharmaceutical companies, giving them rights to manufacture and sell the drug, the Remdesivir, to 127 countries. Remdesivir is presently considered the most promising candidate for the treatment of COVID-19 and the subject matter of the 3 Indian patents granted in 16, 19, and 2020. As I just mentioned, that the licenses involved into the said drug are to provide transfer of technology and also to regulate prices which are given to the manufacturers, is something which Gilead's approach is in coming up with the said patent, and thereby it is demanding that it's come up with a very equitable and a good sort of a proposition in patenting a life-saving drug. Thereafter, possibly the most relevant term in this said license which Gilead has come up with is not only a voluntary license, but it is also a royalty-free license for some time. And here is the catch. It is a royalty-free license till this pandemic A subsides, or if there is another vaccine which comes into the picture, whichever is earlier. So until these 2 scenarios, whichever is earlier, this said license that Gilead has come up with, the said drug would be a royalty-free drug. So hence companies and entities all over the world who've signed licenses are not to worry about paying royalty at the moment or fixing prices based on what Gilead wants them to fix it to. Having said this, I now come on to the approaches and strategies available to combat this monopolization of life-saving drugs or any other life-saving drug which may come into the times of pandemics. As I've already touched upon certain aspects in my introduction of the discussion today, there would be not much issues in understanding the concepts which I now highlight. So the first approach or the strategy which is involved in combating monopolization of these life-saving drugs would be a compulsory licensing. So compulsory licensing, as I'd already defined under the Patents Act, it allows third parties to interfere with the patentees, exclusive rights to be taken by them under certain conditions and under certain terms and conditions. The law provides patentees time to work their inventions and make drugs adequately available, and therefore mandates that no application for compulsory licensing may be filed till 3 years of the grant. As the 3 years period, so in the present context, if we talk about Remdesivir's 3 years, the 3 years period that I had mentioned while I introduced the concept of compulsory licensing is that the main criteria for compulsory licensing was that only after 3 years of filing an application can a third party come up and claim a compulsory licensing, provided those three situations may be met. So in the case of the present drug that we have, the Remdesivir, we find that the 3 years expiry period the 3 years period of this drug has not expired. because the recent patent has been granted in 2020. So hence for this particular drug, this solution is not viable to combat monopolization of a life-saving drug. But nonetheless, we have many more areas that we have in patents law, which can give us some benefits in terms of monopolization, combating monopolization of life-saving drugs. Further, we can also have a strategy adopted wherein compulsory licensing could be adopted through a notification by the central government, as I already mentioned in my discussion during the introduction. So this next is a series of alternative approach which we can use, which is involving the central government, which includes a declaration by the central government that the Remdesivir patents or any other life-saving patents for that matter are subject matter of national emergency, circumstances of extreme urgency, or public non-commercial use, as a result of which compulsory licensing ought to be granted at the time of the patenting filing. So this particular proposition does away with the three years period that I just mentioned in the compulsory license part before the compulsory licensing through the central government notification. So following such a notification, person interested may apply to the controller for a compulsory licensing, and compulsory licenses may be granted in favor of such persons or entities. Apart from this, we have other options too, and what they are that the central government also has the power to revoke a patent that is being exercised in a manner mischievous to the state or generally prejudicial to the public, which I've already explained and touched upon in my introduction. Furthermore, the effect of such revocation, if we see in the context of revoking Remdesivir that the drug that we have presently, the effect would be that Gilead loses all its rights, and the said life-saving drug is into the domain of all people, and thereafter they can exploit the drug howsoever they want to, which doesn't really seem to be a viable solution, because at the end of the day, you also need to see that innovations and inventions need to be protected, along with how public interests need to be protected. Furthermore, another provision in the law for combating monopolization of life-saving drugs is allowing the central government or any other person authorized by it to use the patented invention for the purpose of the government. Thereafter, we see a plethora of different strategies that can be involved in combating such monopolization. Moving ahead, further strategies which could be adopted are that pharma companies at the moment or in the times of such pandemics can go ahead with launching such life-saving drugs whenever they formulate such drugs at their own risk. Gilead would definitely file a patent infringement claim, and then we all suffer a long litigation, and everybody knows how that ends. So this also doesn't really seem to be a viable strategy or a good solution to adopt. Coming on to another solution, which I feel is a best solution so far, and which Gilead has also adopted, is a series of licensing deals, which may be known as voluntary licensing under the scheme of the patents law. Such a voluntary licensing is akin to a contract governed by the usual terms of a contract law, apart from certain conditions imposed by the patent law, of course. So generally, voluntary licensing are increasing the most suitable course of action in mature patent systems as far as patentees are concerned, as they're effectively doing away with the above adversarial steps that I just mentioned. And they, of course, at the end of the day, assure affordable access of medicines to everybody. As for the licensees, entering into the voluntary licensing schemes, this ensures manufacture and sale and consequent access to medicine, which is virtually guaranteed. The third party in this bipartite agreement, that is the patient body and the public at large, emerges victorious, and it's a win-win situation for everybody. But however, such licensing regimes can be successful only if parties make honest and wholehearted attempts to make it work, keeping in mind the vital nature of the drug and not more self-interest. The Remdesivir, so talking about the Remdesivir voluntary license model is based on the information available, which appears to have addressed the potential defects in the licensing system. And how's that? The voluntary licensing of Remdesivir now further goes a little bit ahead as to the present aspects and the problems that I've just highlighted in terms to voluntary licensing. With the license being a royalty-free license, which I just mentioned for the time being, the cost of research and development can be recouped once other drugs hit into the market or the severity of the disease is reduced. And royalty rates may be decided favorably for Gilead once the most distressing times are passed away. So as I just mentioned, this could be a situation balancing the interests of pharma companies along with public interest. So this non-exclusive royalty-free license goes a long way in ensuring that the drug remains affordable in the times to come. Price control is a very important factor in today's aspect when pandemic like this hits nations. So a non-exclusive royalty-free license definitely would lead to manufacturers in India who've signed licenses to control the monetary aspect of the drug. Also, not to worry about the royalty at the moment. And in due course, supply affordable drugs to everybody who are suffering because of this pandemic. Talking about all these situations at hand, we just now come to the main core as to, is patenting the only solution of these life-saving drugs? And how far is the road ahead? And what would be the future of such monopolization tactics which manufacturers or pharma companies are adopting? So as governments around the globe fight COVID-19 outbreak, pharmaceutical companies race to develop a vaccine and potentially secure a patent for it, which is quite obvious. And to speed the process, much of that effort builds on known drugs of other diseases like the Remdesivir. As I'll quote, the World Economic Forum reports that 70 potential vaccines are currently in development around the world. According to the BBC report, research is in progress on more than 150 additional drugs globally, with many pre-existing drugs being trailed for potential usefulness in combating COVID-19. So in the wake of this COVID-19 vaccine and patent sprint, questions arise concerning affordable and universal access of this medicine to all. Will governments, especially poorer ones, be able to afford or secure affordable access to a vaccine if and when one becomes available? Can a patent owner actually be forced to license a COVID-19 vaccine for the benefit of the greater good? Are certain questions that we need to consider, but at the moment, the answer to them is likely yes, depending upon where you are. In light of this, however, in India, on 9th April 2020, the Cancer Patient Aid Association, the CPAA, a charitable organization, has written to the central government for the revocation of the said Remdesivir that has been recently granted a patent. And this revocation has been filed under Section 66 of the Patents Act. This Remdesivir patent application, which has been filed by Gilead Science, has been granted in India a patent on February 18, 2020. And this patent states that Remdesivir is useful for treating a particular family of virus infections, and coincidentally, this coronavirus is also coming into that family. So, in light of all this, the CPAA has urged that Remdesivir may be an effective treatment of coronavirus. Therefore, in today's situation, monopoly rights to Gilead may be imperative to public interest, and that's all what we've discussed at the moment. Hence, the patent should be revoked under Section 66 so that generic version of the drug shall be made available to people at large. Furthermore, CPAA has also urged that this grant of patent is not patentable as it lacks novelty and inventive step, and also falls within the provision of 3D of the Indian Patent Act, which states that anything which lacks novelty or doesn't have an inventive step, as already established in my discussion before, cannot be patented. So lack of novelty and inventive steps are the grounds of both post-grant opposition and revocation under Section 64, and hence the said claims by one of the associations recently. So what has to be seen in light of all this is that what Gilead right now is doing seems to be playing its cards right, with providing the drug free of cost at the moment, free for local manufacturers in an altruistic move rarely witnessed before. This sort of a situation has not been witnessed by any of the pharma companies or of any of the entities in the world before. However, uh, Gilead coming up with a good proposition of a royalty-free, non-exclusive voluntary license, which seems to be reasonable at the moment. It is now time for Indian pharma companies to keep the end of its bargain and to take all steps necessary and expedient towards the affordable measures and the affordable access to Remdesivir. As the licenses allows licensees to set their own prices for the drug, as mentioned by me, Indian companies would need to ensure minimum or no profit margins and rapid manufacture and export thereby could gain from the same by putting India back on the map as once it was in terms to pharma market and pharma expansion. Thereby, having read through everything and also seeing how the patent law has been advancing and what all are these statutory protections that one can get one can get to combat such life-saving drugs when entities want to monopolize such life-saving drugs. The only concern right now to see is that how do we balance technology expansion, or how do we balance innovation and inventions on one hand, or trading or patent rights on one hand, and on the other hand, how do we balance out affordability to a mass scale of people during such pandemics, which has created a lot of ruckus in the entire world. Obviously, revocation of a patent under Section 66 may give birth to a number of controversies and can weaken the Indian patent framework as well. Furthermore, we also have, as I highlighted, the provisions of compulsory licensing under Section 92, which could also be certain things to balance out such practices. But what has to be seen at the moment is how do we monetize patents at one end and how do we keep public interests at the other end. Having said all this, perhaps the Gilead, which assigned the voluntary license agreement to manufacture Remdesivir and the distribution that it's doing in 127 countries is a remarkable step, which I was going to. And having said this, I would like to conclude my discussion on the topic of COVID-19 and impact on life-saving drugs. And I open the floor to discussions and questions, if any.
So I request Siddhi to just take up the questions from the chat box for the speaker and keep covering the same. Siddhi, if you can hear me. Siddhi, can you hear me? Siddhi, can you hear me? Siddhi, can you hear us? Or let me take it up if Siddhi is not here. So the first question we have from Advocate Zoya Mehta. Yeah, she's been asking, the pharmaceutical companies are known to skim their profits from their novel drugs, having a monopoly over such a drug, though the Patents Act. How does one balance this with the need of the hour during a pandemic?
Absolutely. Thank you for this question, first of all. The balancing out regime has just been elaborated by the discussion that I just went forward with. As mentioned in my discussion also, we have various statutory balancing provisions into the legislation, which are the compulsory licensing provisions, or there are provisions in relation to voluntary licensing or different licensing. Also, there are provisions in which the central government can come into the picture in such times of pandemic and by a notification formulate a compulsory licensing for third parties. Also certain endeavors which the entity, the US Gilead Incorporation, which has come up with in terms to giving a non-voluntary license, a non-voluntary royalty-free license, which are remarkable steps towards balancing such aspects under the patent regime.
So this is the first question, and now we have the second question. It is like, how important is to obtain license under Section 84? Is it not the prior use of the drug entitled to earn the profits on the patent law as it is in the like Trademarks Act?
I would like to go through the question once again, if I could direct the question into the chat box.
How important is to
How
obtain
important? Yeah.
Shall I repeat again?
I've got the question. Absolutely. Thank you so much for this question. So under Section 84, it's not really that important to go forward with a license, as licensing is a entire discretion on the patentee in totality. So it's not really that mandatory for getting a license under 84. Furthermore, it's absolutely different from the Trademarks Act, as mentioned in this question.
Okay. And next we have it from Priyanka. Could you kindly explain enhancing in efficacy again? What is the period of renewal of patent? What is the, I think it's not complete. Yeah, what is the period of
I've got the
renewal of
question.
patent?
Absolutely. Yes. So firstly, thanks Priyanka for your question. What I meant and what is meant by enhancing the efficacy, when we deal about pharmaceutical drugs at hand, we talk about pharmaceutical efficacy in terms to the efficiency of the said drug, as to how efficient is this drug in curing the said the diseases at hand. So this is meant thereby by the efficacy. The efficacy can also be established in terms to various strains which are added up to combat a particular disease, which in totality lead to the efficacy of a said drug. So this concept of efficacy under Patents Act is that if supposedly the said a drug, as I mentioned, under second, if somebody wants to go for a second planning of getting a patent, in that scenario, what entities do is that they modify the efficacy to some level so that they can get another patent, and they can. It's sort of similar to renewing, but because they do not want to renew it, they sort of change the specification maybe, which in terms to increase the efficacy, or it's just a brief modification, which also falls under the aspect of evergreening, which I just mentioned in my discussion. So hence, in light of this, if there is no enhancement of an efficacy of a drug, a patent cannot, an invention cannot be given a patent. And as regard definitely a patent can also be renewed. We have renewal criteria under the Patent Act, which can be found in the provisions of our patent law. And after the term which we get a patent is of 20 years, and thereafter 1 year before a patent is about to expire, we can definitely apply for a renewal.
Thank you so much for this. Then we have Advocate Sangrito. He's asking, can emergency use authorization be given to a drug under research, for instance, Remdesivir? What about lobbying by Gilead? Can the novel coronavirus be patented? Kindly elucidate.
So this was the entire discussion. Thank you so much, first of all, for your question, Sangrito. So Sangrito and I, we are colleagues back in our former office. Nonetheless, the entire discussion of today was primarily to see as to how can we combat monopolization of these life-saving drugs. Of course, in the very first aspect, if we look at by Dr. Sauls, the polio virus was never patented. In history, we also see that insulin was never patented. So like this, we see that there are certain life-saving drugs which the patentees never wanted them to get patented, so that they can give free access of these drugs to everybody. But on the contrary, today we need to understand that we are in a globalized economy. We are in an economy which is fast, rapidly evolving. Hence, we now need to see that how can we balance out both the platforms? How can we balance public interest? How can we balance vis-a-vis patent rights, or meaning thereby monetizing the patents that we have at hand? So, patenting coronavirus drug would be in terms to something like coming on to a equitable solution, how Gilead has done. So at present, we do not really have a life-saving drug at hand. The remdesivir is just an experimental drug which has been come up, which has been which has been developed by Gilead. How Gilead is tackling this problem is something remarkable. As it's coming up with an equitable approach. I think some sort of similar approaches only would be the need of the hour if we get a vaccine or a drug for this virus.
Okay. So then we have it from Siddhi Mittal. How to enforce the patent law in India? Don't you think there is a need to set up special IP patent courts to deal with it?
Don't you think? Sorry, I couldn't get
Special
you.
IP patent courts to deal with it. There is a requirement of setting up of new special IP patent courts for enforcement of patent laws in India. So that's what she wanted to ask.
So thank you for your question. We already have a separate mechanism altogether, the controller office, which deals with the patent filings and which deals with patent applications and initial objections and oppositions given by third parties. As such, I feel there is not much of a requirement to venture into an independent court setup, which primarily deals with patent. As we have the Intellectual Property Appellate Board also, which deals with appeals from the said patent, which deals with the appeals from IP cases from the Controller Office. And also we have appeals which lies in the High Court, and I feel that's more than sufficient. The scale as to deciding cases is also going well in the said scenario. And as it's a very harsh truth that I may say, establishing new courts, we all know, would not really solve the problem. Pendency will still sustain. We have new courts coming into the picture for different legislations and different laws, but still pendency is the major cause of concern.
Please,
yeah. So the next question is again from Sangreto. He's asking, how do you see India's pharmaceutical supply chain linkages with China affecting the price in the market and public affordability, considering a complete no-no to China?
So what right now presently Gilead is doing, that Gilead has adopted manufacturers in India and Pakistan to supply this drug into 127 countries. So the technicality will mainly remain upon how India would like to go ahead with the supply chains in relation to China. However, the statistics show that China, being a country which has already developed and claims to develop certain existing life-saving drugs to combat coronavirus, and also has jumped into the rat race of filing the patent for these drugs. So I don't really see a linkage between India pharmaceutical supply chains with China in the present scenario.
Okay. So the next question is again from Siddhi. You just said that novelty shall be the basis of claiming the patent. What sort of the novelty is sought generally for obtaining a patent for a drug?
Absolutely. Thank you for your question. So when I say novelty, I mean it should be something new. So when I mentioned about novelty aspect, I also mentioned about 3D, Section 3D under the Patents Act, in which I mentioned about a long list of salts, ethers, different sort of combinations, etc. So per se, they are not novel, and there are certain combinations which are already in the market. So for drugs, the standard is really high, obviously, because patent gives monopoly rights to these inventions. So for a drug to qualify for under novelty is something which it would either enhance or combat a particular disease in a way which the other existing drugs did not combat. So this could be one of the criteria for testing novelty drugs.
So yeah, we have one more question from Zoya Mehta. She is asking the famous drug for H1N1 influenza Tamiflu is sold at a very high price, which happens to be highly useful in combating the symptoms leading to death. Why do you think that it still sells at an inflated rate? What makes the governments to initiate balancing procedures with regard to the availability of the drug to masses at reasonable rates?
Absolutely, I understand your concern and thank you so much for your question. We have various other vaccines and also we have various other drugs present in the market, which entities have come up with only monopolizing the said drugs by filing patents. And that's what when my discussion, that's where in my discussion I mentioned that in normal course of action, entities generally involved in monopolization of drugs and they go forward with getting patent rights over the same and they pitch in prices which are really high because in which we have after effects and we have drastic bad effects in all over the world wherein people cannot afford such drugs because they're capped at so high prices. So this is a prevalent practice which we unfortunately with a very sad heart we are facing and because of that
आपने बोल दिया अपना मुझे अपने तरफ से मुझे सोचने दो
Let me check Anushka. I think somebody
रॉयल्टी नहीं लेना 1000 रुपया हम ट्रेनिंग रखेंगे करके
yes, you can continue.
All right. So having said that, this is a very sorry state of affairs right now that in normal situations, that's what I mentioned in my discussion that entities do monopolize patents by filing, do monopolize inventions by filing patents of drugs, especially life-saving drugs. And there should be measures and there should be aspects wherein governments should plan to combat such arenas. But however, in such times of pandemics, this is not the question which I mentioned in my discussion. In such times of global crisis, monopolization of drugs will only lead to a mass destruction. Already we are facing that. Very sorry state of affairs at the moment, but this is what is actually happening when we don't have a pandemic. But in times of such pandemic, I feel we need stricter measures as compared to the area when we have normal times.
So this is the last question from Daksha Sandhu. She's asking how can balance of technology, affordability and inventions could be maintained during this pandemic situation? What actions Indian government can contribute at present? So it's like generally a suggestion we require from you or what is the mode and modality to control at this pandemic situation she's asking.
Thank you so much for your question. As I mentioned in my discussion, the last pointer, which was that what Gilead has come up with is a very unheard practice, which is very beneficial if Indian market and Indian pharma companies scale up to the level today. As the PM's model of self-reliant India says that we need to make ourselves self-reliant, I feel that this the license which we've received, which we have signed with Gilead, will be a very remarkable step in furtherance to keeping the pace not only in technological development but also boosting the economy and also putting India back on the map as we were before a leading pharma manufacturer. But as I mentioned that that Indian pharma companies also would need to be very stringent and they need to take quick action and they do not because the entire power of keeping up and keeping a tab of prices are on them. So they would have to get away with the aspect of profit making for themselves at the moment if they want to see a better India. So.
Thank you for answering all the questions one by one, Anushka, and we have saw that you have well versed with this topic of patent law in your small journey of practice which you are doing, and we hope that you will remain doing it in future also. With here, I
Thank
would
you so much for this opportunity.
I would give it to Sanha to thank you for the today's webinar on this technical subject, which generally doesn't everybody wouldn't like to take it because it's more of a technical nature. So it's nice to hear you. And from here, Sana, over to you. Please thank the speaker for today.
Thank you so much, ma'am, for this wonderful session. We are honored, ma'am, here to you
you.
for this topic, that is the patent law, COVID-19 impact on drugs. This session, ma'am, was very interactive and informative also. So I hope that all the participants, they have cleared their doubts and have a clear picture of this patent law. Thank you so much, ma'am.
I would like to mention here that if there are further questions or there are further deliberations, we may continue the same on any of my social handles as well. We may take the discussion thereafter on that as well. And thank you, Mr. Nitesh. Also, a wonderful opportunity, especially for young lawyers. And with our limited knowledge, we are here able to speak whatever we've been seeing, either from our client's perspective or what is happening around. Thank you so much. It was wonderful. And I thank the audience also. Thank you, everybody, for joining us today here and giving your valuable time. Much appreciated.
Thank you to this
Thank you.
pandemic, which has given this opportunity to all of us to get connected to this webinar.
Thank you so much, sir, also for organizing this webinar and
you.
making this COVID time so effective and knowledgeable for all of us.
Thank you, Sana. Thank you so much for this. Anushka, one thing in the last I would like to add that our viewers are always asking for certain citations. Those which you have mentioned, I would like that if you can share those citations, I can share with them, with the groups which we have made. So
exactly, I was about to ask you, sir. Thank you, Nitesh, sir, for asking this question. I was about to ask the citation.
I know, Shobit, you know, your intentions are always clear from your...
Sir, I always make notes, sir. See, my diary is always there with me. I always attend and make notes.
Absolutely. As I did try to mention all the citations, be it Halsbury Law's page number as well. But if any I missed out, I'll definitely like to either clarify right now or maybe drop in an email if I don't have the citation.
You just drop into me. I'll just share it with the group. Okay, it will reach to all of them.
Thank you, sir.
I'll definitely do that. I'll definitely do that.
Thank you, Anushka, for the same. We'd like to see you in future all other subjects also. Bye.
Absolutely. Thank you, sir. Bye.
Thank you, sir.